Hello and welcome to my daily take Goa Current. Goa Current is a short video where I analyze and discuss important news of the day and give you a short explainer so that you are better informed than what you are reading elsewhere. Today's topic: when 400 employees of diocesan institutions run by the church work without salaries, who is defying who? Now, nearly 400 teachers and other employees working in educational institutions run by the Diocesan Society of Education have reportedly been compelled to work without receiving their salaries. These are not employees who abandoned their classrooms or failed to discharge their duties. They continued working, but their salaries were blocked because the Goa government refused to recognize appointments made by the management of these minority institutions. And I will explain. Now, the matter has reached a far more serious stage. The Bombay High Court at Goa has now issued show cause notices in a contempt petition to the Director of Education, Shailesh Zingade, and Deputy Directors Manoj, Sawaikar, and Sindhu, asking them to explain why contempt proceedings should not be initiated against them. The notices have been issued because the Diocesan Society of Education says that the government authorities failed to comply with the High Court's judgment of October 3rd, 2025, and that judgment is very, very important. And I'll go into it a little later. But the Director of Education and his two deputy directors must now explain why these contempt proceedings should not be initiated against them. Now, at the heart of this dispute is Article 31 of the Constitution of India, which gives all religious and linguistic minorities the fundamental right to administer and establish educational institutions of their choice. This is not any concession. This is a constitutional protection. Now, the Diocesan Society administers more than 138 schools across Goa. The Directorate of Education refused to accept appointment letters issued under the signature of the society's chairman and insisted that they must instead be signed by the managing committee of each individual school. The society challenged this interference, maintaining that it is the society that was the management constitutionally entitled to administer its institutions and appoint their staff. The High Court ruled in favor of the constitutional autonomy of the minority institutions. It held that the government could prescribe qualifications and enforce educational standards, but it could not impose an appointment procedure that unjustifiably interfered with the institution's right to administer its schools. In other words, the education department can ensure that a teacher possesses the necessary qualifications and that the education standards are protected. But it cannot use regulation as a backdoor to take over the powers of the administration of these schools that Article 31 places in the hands of the minority institution. Now, the Goa government was entitled to agree with the judgment. It was entitled to challenge it before the Supreme Court, and it did so by filing a special leave petition. But filing an appeal does not automatically suspend the judgment that was being challenged, unless the Supreme Court grants a stay. The High Court's judgment remains in operation and must be obeyed. That is precisely the point that the High Court made when the judgment sought another adjournment of the contempt proceedings. The state argued that its petitions were pending before the Supreme Court and were scheduled to be heard on August 25th. The High Court, however, noted that the Supreme Court had not stayed the October 2025 judgment. In the absence of that stay, the High Court said it was bound to proceed with the contempt matter. This is where it becomes very, very difficult to defend the government's position. An appeal is not a license to disregard a judgment. A pending special leave petition cannot be treated as though the government has already obtained a favorable order from the Supreme Court. That is why the Goa government cannot create its own stay by merely filing an appeal. Now, why are the teachers and employees of diocesan schools being made to suffer like this with their salaries, appointment letters, promotions all getting blocked? The teachers and staff members did not frame the appointment procedure. They did not create the dispute between the education department and the diocesan society. They reported for work. They taught students. They served their institutions. Yet, their household expenses, loan repayments, children's education, and financial security have been placed in jeopardy because the government withheld their salaries. Please note this. Now, 400 employees are suffering because of this. 400 employees. And this is indefensible. The implications go beyond these individual employees. The government's actions raise a very important and a disturbing question. Can the education department use salary approvals to exercise indirectly the control over minority institutions that it cannot exercise directly under Article 31 of the Constitution? Now, the government, by using these backdoor tactics, would be able to cripple the administration of a minority institution by simply shutting off the salary pipeline. Former Congress President Amit Patkar has now given the government 10 days to implement the High Court's directions, warning that the party will launch a statewide democratic agitation if the government fails to act.
वो एक very important issue because it is related to education. एका साइडीन अनएम्प्लॉयमेंट रेट आमची वाडटा. भुरगीं जी शिकतात तांकां आज नोकऱ्यो ना. सो ते काउंटर करपाक आज प्रमोद सावंत जे 138 इन्स्टिट्यूशन गोंयांत जी आसात एज्युकेशन इन्स्टिट्यूशन ती काबार जावची. थंय टीचर मेळचे न्ही. थंय नॉन टीचिंग स्टाफाक वचचे न्ही आनी ते इन्स्टिट्यूशन बंद पडचे हो ह्या भारतीय जनता पार्टी सरकाराचो प्रयत्न आसा. हांव ह्या सरकाराक चेतावणी दिता. After all, they are institution. After all, they are religious institution. ज्यांच्याकडे ताकद ना आपलो आवाज व्यक्त करपाक ताकद ना रस्त्यार येवपाक. पूण ह्या 138 सगळ्या स्कुलांच्या तर्फे ह्या सरकाराक डॉक्टर प्रमोद सावंताक आमी चेतावणी दिता आनी एक डेडलाइन दिता की फुडल्या 10 दिसां भितर जर तर गोंय सरकार ह्या हायकोर्ट ऑर्डरीचे जर तर इम्प्लिमेंटेशन जर करना जाल्यार आमकां रस्त्यार देंवचें पडटलें. आमकां रस्त्यार देऊन तुमचे कडेन हे इम्प्लिमेंट करून घेवचें पडटलें. कित्याक आज 138 स्कुलांनी जी भुरगीं शिकतात तांच्या भविष्याचो आज प्रश्न आसा.
The political ultimatum may increase the pressure, but the government should not require either the opposition or contempt proceedings to understand its basic responsibility. And this is what is very, very important. The Goa government must therefore tell the public whether it deliberately withheld these salaries despite the absence of any stay, who authorized that decision, and what urgent arrangements are now being made to pay every affected employee. This is not merely an argument about whose signature appears on the appointment letter. It's about whether the Goa government respects Article 31, whether it obeys judicial orders, and whether hundreds of teachers and school employees can be deprived of their salaries while the state waits and hopes for a different verdict. And this is what this particular vlog is all about. Now, before we end this, we ask 5 questions to the Goa government. Why were nearly 400 teachers and employees made to work without salaries? 2. Who are the blocking of their salaries after the High Court's October 3rd, 2025 judgment? 3. When there was no Supreme Court stay, why did the government not comply with the High Court directions? 4. On what date will every affected employee receive the full salary and arrears due? Question 5. Is the government using salary approvals to undermine the rights guaranteed to minority institutions under Article 31? Now, Goa teachers deserve their salaries and not excuses. And we must know why the government is meting out this stepmotherly treatment towards minority institutions in spite of a High Court order which it has to obey. This was today's Goa Current, and this is Ink Goa, and I'm Shujoy Gupta.